and this is SB2535 relating to geothermal, and it allows the counties to adopt ordinances to regulate geothermal resources exploration. The chair would like to add that there is a SD1 that we will be that's been circulated, and for those in the public that needs a copy, there's a couple of them here as well as here as well. And if you have testimony with regards to the old measure, that's fine as well. So we'll proceed with testimonies. DLNR?
DLNR stands on a written testimony in support with comments.
Thank you. And chairs, if you want to ask questions, feel free to do that as we call the testifiers up as well. Okay. You want to?
I was going to wait till the end. If that's good. Some of the people might answer.
Oh, okay.
Yeah.
Okay. Otherwise, she's free while she's here. Okay. All right. DBED. Good afternoon. Sends communication in comments as well. Hawaii Association of Realtors.
Chair of the committees, Gary Slovan, Mary Bergier was going to testify, but she had to catch a plane. So we are in very strong support of the original bill. I've taken a quick look at the proposed SD1, and to be candid, can't be sure yet if that satisfies our overall concerns. So we'll have to take a look at it.
Okay,
thank you.
Did you get a copy?
Yes.
Gary? Okay.
Sure.
Thank you.
Just in case
Sure.
it's not available.
Sure. Senator Ruderman. Gary.
Thank you, Gary. I was hoping to ask Ms. Berger, but I noticed that she left already. No. I have some realtor friends that have concerns about geothermal development because it's had an impact on property values in the vicinity. How did you decide to take the position? Did you poll your members, or how did you decide to take the position on this?
Yes, just briefly, the realtors meet every week. There are quite a few. There are a number of committees, and we follow quite a number of bills, and so we have very full discussions. As a matter of fact, those meetings tend to go on for about 4 or 5 hours. So these things are pretty well vetted. And I think the balance that was trying to achieve here is that the county, in the original bill, was given jurisdiction within a mile, but not after. And I think the basic theory is that we are trying to develop non-fossil sources. The geothermal has worked well. This is coming from the discussion, not my own direct experience, of course. And the feeling is that if you don't have, and it also, I think, the feeling is that it is a matter of really statewide significance. There's great potential for the development. But if you adopt local restrictions on the development of geothermal, it's going to hamstring that development and hurt its long-term use.
Okay, thank you very much.
Thank you. Yes, Senator Thielen.
Sorry, Mr. Slovan, just because you might be leaving.
Oh, no, I'll stay.
Oh, well, anyway, since I started. So one of the changes under that proposed SD1, the original bill kept the county concurrent jurisdiction if the geothermal was within 1 mile of residences. And in the proposed SD1, it takes that away. Would that change things for the realtors because you are representing homeowners? You know, people buying and selling homes?
Well, the problem I have is that I haven't really had a chance to analyze it, and some of this is related to statutory interpretation. So I'm familiar with the bill that was before you, but I can't really give you an opinion on that.
But would it be fair then to ask whether you would need to go back and discuss it with the realtors before making a recommendation on that kind of change? Because it might be something that would that be something that might change the discussion among your members, or no?
I think that it depends. To be candid with you, it depends. I mean, we thought the bill in its original form would achieve is a balance, giving the county jurisdiction within this area, but that the state regulation would be respected for anything beyond that, and that what the county did would not be inconsistent with the state regulation and, frankly, would not inhibit the development of geothermal. Now, what I will do is, after the hearing is concluded, I will send this language to the folks, particularly some folks on the Big Island who have focused a lot of time and attention on this, and probably get a reaction from them fairly quickly.
Thank you.
Okay, any further questions? Okay, hearing none.
Aloha, Chair Noe,
Aloha.
Chair Nishihara, Chair Gabbard, other senators here. This is a blessing compared to the next era hearings, so I'll wait quite a while. The switch from fossil fuels to renewables should be considered a win-win. It should be that we're moving as a state away from harmful effects of fossil fuel and towards clean energy. But unfortunately, a lot of our movement towards clean energy seems to be pitting rural communities against urban centers. For example, we put up windmills behind Waimea Valley, a sacred Hawaiian area, when the number one wind spot on Oahu is Black Point, just off the Ainahaina coast to Haunama Bay. Now, of course, no one is suggesting that because that's the urban area. But it's okay to dump projects into rural communities. That does not create a family or ohana. The second issue is that nobody that I know of is saying that we shouldn't be looking for geothermal in the saddle area of the Big Island. I understand that there are hot spots that have been found in that area. There's hot spots on the west side of the Big Island. But instead, the emphasis is we dump everything into industrializing Puna. So there's now a proposal to expand the Puna into an RFP that Helco basically has out to see how much we can build there. There are ways of making geothermal safer, and there are ways of making it more destructive. The idea that we could pound the ground in the daytime is one thing. How many people would want to see the Ward Warehouse area or Waikiki building skyscrapers by pounding from 6 p.m. to 6 a.m.? Nobody would think of doing that because that's an urban area. But it's okay to pound people in rural communities. Somehow, that just doesn't seem fair. This bill basically says that the county should be preempted by the state. And a good analogy, I think, is the Waikiki Beach. The land is under DLNR control, but police monitor it for health issues. They can give out citations. Here you're saying that geothermal underground is a state resource, but the county should be restricted from regulating health issues on the surface. Make it uniform. If you want just one level of government for all, then have DLNR patrol our beaches. Thank you.
Thanks for your patience.
Thank you, Chair. Aloha, Chair Inouye, Nishihara, and Gabbard. SB 2535, as written, would give PGV a retroactive pass on their blatant violation of the county law banning nighttime drilling within 1 mile of county residence because it's dated back before the law was passed. There's in PGV's unsuccessful March 3rd, 2015 motion to dismiss the PPA versus PGA lawsuit against the night drilling, they argued that in the absence of any language specifically covering night drilling in PGV's permit or in the framework of state laws regulating geothermal drilling and operation does not equate authorization of the county council to prevent such activity. SB 2535 adopts PGV's argument to unduly extend existing preemption law by adding a new phrase. The absence of state law shall be interpreted to mean that the power to regulate geothermal resource development and geothermal resources exploration has been reserved to the state. DLNR is also a plaintiff in this in the pending lawsuit in circuit court. SB 2535 then preempts county geothermal law by declaring geothermal generally is a topic for state control. The regulation of geothermal resources development and geothermal resources exploration shall be reserved to the state unless delegated to the counties by statute. However, PGV obtained its existing geothermal resource permit under state laws that delegated geothermal permitting to the counties, HRS 205-5.1 and 205-5.2, but those laws were repealed by Act 97 in 2012. Regarding the county's night drilling ban, SB 2535 is intended to preempt DOH noise rules. HAR 11-46-13 says a county may adopt and provide for the enforcement of ordinances regulating any matter relating to excessive noise. In any case of conflict between a state statute or rule and the county noise ordinance, the law which affords the most protection to the public shall apply. That regulation recognizes why county geothermal authorities should not be preempted for the better protection of the public. OHA said it has concerns that the bill does not address the need for procedural safeguards that provide clear and transparent processes, including input and participation opportunities for decisions relating to geothermal resource development and exploration. In addition, this matter appears to nullify the procedures already in place on a local level in both Hawaii and Maui counties without providing alternative procedures and recommendations reinstating the permitting process. The nighttime drilling ban, fracking ban, the nighttime drilling ban in particular was passed with great effort by the county because PGV drilled 24 hours a day for months and people could not sleep. There's a lot of people that live around that power plant, and the community was so upset that they went with hundreds of people to the county council, and that's where that law was passed. I don't think it's right for you now to just throw that away. So SB 25 is a preemption bill that deprives the counties of authority in geothermal matters. It's a legislative act that interferes with ongoing litigation in the Hilo Circuit Courts of Punapono Alliance versus PGV to enforce a county nighttime drilling ban. As such, it's special legislation intended to benefit a special interest, PGV. In Governor Ige's January 25th, 2016 address to the legislature, he said, a few years ago, we saw the demise of the super ferry. Its failure has been attributed to environmental objections and a hostile court, but that is not exactly what happened. The fact is the state failed to follow the law when we tried a legal end run. It also failed. The point is the state should have followed the law and done the right thing in the first place. SB 2535 is like a special legislation that attempted to save the super ferry, the legal end run referred to by Governor Ige. The question of enforcing the county night drilling ban should be decided by Judge Nakamura in the Hilo Circuit Court, where the case has been pending for more than a year. Language in 2535 is almost identical to PGV's motion filed on March 3rd, 2015 to dismiss the lawsuit to enforce the night drilling ban. Judge Nakamura denied PGV's motion. SB 2535 wants to give PGV and DLNR a special legislative benefit. Appropriate discussion of these issues should continue to take place in the court, not in the legislature.
Senator Rudin? Yes, questions? Senator Rudin.
Thank you for coming all the way over here, by the way. Are the effects of being a neighbor to geothermal development, are they limited to 1 mile?
No, they're not.
Can you elaborate on that? Can you tell us what?
Well, they've had, I think, 17 declared civil defense emergencies at that power plant. 1991, they had a blowout, and the effects were felt at least 10 miles away. Communities, I don't know how many people were evacuated, but miles and miles of people had to be evacuated. And they've had a whole number of things, and that continues up until at least August of 2014. During Hurricane Estelle, they decided to continue to run the power plant, knowing that the trees were going to knock the power lines down and that they would have to vent into the community. There's 130 or so people that were injured during that because they were trapped in their homes. So people were trapped in their homes because of the hurricane. The roads were blocked and they were gassed by PGV. We have 12 people that claim they were knocked unconscious during that event. PGV and Department of Health say that that's not possible. That's going to be decided in the courts as well. That litigation should be coming up before August. The statute of limitations will be this August.
Thank you. Thank you,
Okay,
Chair.
I have a question, Bob. When PGV started again after the blowout, there was an established county ordinance as well on the relocation fund. Okay. Do you know offhand how many people took advantage of the county's funding and moved out?
I have a rough idea.
And my understanding is some of them went back again.
I do not know if some of them went back again or not, but I had tried to get that and a number of other people. For the first 8 or 10 years or more, only 1, 2, maybe 3 people were able to qualify. They had all kind of reasons why you couldn't qualify. I finally sold my house for $75,000 and left, and I never got any relocation. I lost $175,000.
Did you sell it to the county then?
No, I
Because
sold it. I had to.
According to their ordinance, I think it's either relocation or purchase.
They refused to. They refused to buy my house, and they came out and there were different things. First, there was problems with the roof, so I changed the roof. Then there were problems with the plumbing, so I changed the plumbing. Spent like at least $5,000 trying to, and I never was able to qualify. And like I said, out of all the people that applied over the first 10, 15 years or whatever, only 2 or 3 were able to ever qualify. Then, after all the hoo-hoo started and the county started passing laws, then they reinstituted. All of a sudden now they've relocated, I don't know how many, 10 or 12 families there, and they have a waiting list of probably 30 more people that are trying to get out.
Okay. Thank you. Thank you. All right. Okay, I'll read out the names. All of these are in opposition. They were all individual communications. Joseph Kong, Teresa Nakama, Amara Karuna, Sylvia Dolna, Shannon Randolph, Melody Reyes, Kimberly Crawford, Christopher Biltoff, Anna Kaho'opi'i, Lisa Hamo, Megan Balzac, Serafina Gajate, Caroline Delano, there was a Sharon, Ted Orston, L.S. Knight, Michael Helms, Carrie Marks, Julia Hall, Bill Smith, Joe Castle, Mary Lax, Mary Overbay, Bill Bugby, Dr. Chris Camarillo, Thelma Travis, Claire Loprinzi, Michael Roy, Patricia and Andrew Leo, Tulsi, no last name, P.E.K. Aloha.
Thank you, Representative Senator Inouye and Senator Nishihara and Senator Gabbard. My name is Mary Townsend. I'm with the Sierra Club of Hawaii, and we're testifying in opposition to this bill. I will have to take the SD1 back to our committee to review the language, but I can tell from the fact that the first section remains the same that my members would be in opposition to this. We're supporters of renewable energy, as you know, and we want to see all of our renewable energy resources used to the greatest extent possible, but not at the expense of any specific community. And home rule, protection of the jurisdiction of our counties, which know the peculiarities of our communities best, is essential to ensuring that the best interests of each community is well protected. So in general, we're opposed to any attempt to sidestep county regulatory oversight of any renewable energy project because we want to see renewable energy projects done well. Thank you.
Gary
The language,
Sloven with...
I'm sorry, Gary
Yes.
Sloven of Hawaii Associated Realtors. I did send the language to the members that have been working on this, and they said they would be supportive of the new language. I just want to pass that on.
you did electronically. Okay. DLNR, Cardi, or Director, maybe both of you, or Cardi. And thank you for being patient as well. During the Ways and Means hearing with regards to the agency's budget, and I was rather happy that the department recognizes that you will increase your engineering staff, and you did mention that in the budget there's a position, and you did mention what the person would be doing, concentrating on geothermal resources. And in the past, so did you use the staff before the request came in? How did you manage doing the enforcement with regards to the process, geothermal activity?
Okay. Just a clarification that the geothermal staff was there into a certain point in time when the legislature abolished these positions. In 2009, I believe, because of the push to get renewable energy back online, they provided additional positions. So the positions were there, I think, back when the original leases was abolished by the legislature and restored back in 2009. I think that's what you're referring to, the restoration of these.
Yeah, because I left, you were still intact, and I left in 2008, and I'm back again, so I was kind of surprised, but I was happy to hear that you're forming back.
Restoring it, and I guess the question you asked was how were we doing it before? Well, we always had an individual on the island of the Big Island to monitor the activity and to regulate the well drilling and so forth. I guess during that period that renewable energy was somewhat stagnant, I guess that was the intent of the legislature to abolish those positions. So there wasn't a whole lot of activity. But when there was this push to develop geothermal or other renewables, this is the time that we establish additional positions to ensure that not only the wells can be drilled safely, we also ensure the protection of the environment, water quality, and other issues as well, along with the Department of Health.
Is there anybody from Department of Health here? Okay, not seeing that, but I'm glad again to say that the department is serious about its job to monitor, and we've neglected the state in the past to do its job. I think it's the responsibility of DLNR as well as Department of Health. So I have a meeting with them as well. But I think this is such an enormous project, and it's been going on for 20-something years. But my hat goes out as well, though. I have to give, and I think Mike is still here, that PGV has responded to the community, like holding quarterly meetings and talking about what has been transpiring in the industry. But as well, I think it's our job. It's the state's responsibility, to continue the monitoring as well. And so I thanks to Director, to seeing that hopefully we'll try and protect your position as well. But, I think the concentration on this resource is so important. And the issue and why this is come up as well, I wasn't here when the legislature also allowed DHH lands to manage the resource, or allowed to create geothermal resources on DHH lands. And we never know when that would come up. And it can, they have lands statewide. So, recognizing that as well. And that's why, to me, I think enhancing the ordinance and making sure that, it's under state law, but to enhance the statute, but also recognize that working with the counties as well, just hopefully address the situation with regards to moving on thereafter. Wherever the development occurs, then pay attention, because DHHL comes up with some proposals, then at least by experience that you folks will be on board. I'd like to speak to PGV as well, but any questions of Thielen, our Senator Thielen?
Thank you. Thank you, Chairs. Hi, Cardi. So, in looking at the statute, I noticed that the state reserves mineral rights for state lands and lands that the state ends up getting, but geothermal could be on private lands as well as state lands, correct?
Yes.
Okay. And would you classify geothermal drilling as an industrial type use?
Geothermal drilling for exploration or for development?
Both.
Anything. I don't know if it's an industrial use. It's exploration. I guess it depends on what.
So if
Into
you're,
Chapter 205, if it's a permissible use in ag, rural, urban, or conservation.
well, I guess that's the point I'm getting to. Under the proposed language in the bill, county zoning, you couldn't zone for geothermal because the state would have the exclusive regulatory authority and the counties could not implement any laws dealing with geothermal. So you could have a geothermal operation in the middle of a residential neighborhood?
No, I think
Would you consider that safe?
I don't necessarily agree that the county cannot. When you look at land use entitlements,
The bill.
Yeah, but this doesn't affect Chapter 205. This is affecting Chapter 46. Chapter 205 in ag, rural, urban, the county still has the authority, and I believe geothermal is a permissible use under ag, rural, urban currently under 205. So this bill, although it affects Chapter 46, it doesn't necessarily take away the land use jurisdiction of the counties.
So if it's a permitted use under 205, but the mechanism the counties use is they take their authorities under 205, where the county has the exclusive authority to zone in the urban area, which would include residential neighborhoods. Wouldn't this bill then deprive the county of that zoning authority in those urban neighborhoods and say the state has the exclusive authority to regulate geothermal drilling?
Well, it's just saying that we would have the authority to issue permits for the drilling.
It says here that provided that the regulation of geothermal resources development and geothermal resources exploration, as those terms are defined in section 182-1, shall be exclusively reserved to the state. So if it's a permitted use under Chapter 205 under state law in the urban district, then under this language, the county zoning, they couldn't zone for what would be.
Well, I don't think this, in our current administrative rules, Chapter 183, we're just reaffirming that we have the authority to lease geothermal resources on the state lands and regulate all drilling. That's already in our statute and in our rules.
But if we amend this law, wouldn't that change?
Well, it doesn't amend Chapter 183.
I know it doesn't change your rules, but the law supersedes your rules, doesn't it? So under this language, wouldn't it mean that the county wouldn't have the authority to zone in the urban district?
That's a question of law, I guess. I would defer to our attorney.
You can stay with the elected attorney. Tom, can you come forward to and you introduce yourself, please?
Thank you, Madam Chair. Tom Ye, who is counsel for PGV. And one of the questions you had, Senator Thielen, was what this, and I'm looking at SD1 for the moment. It does say exclusively reserved to the state unless delegated to the counties by statute. That's still possible under this proposed bill. The primary concern, and I'll give you the example that leads us to really strongly support this bill, is in 2012. In 2012, PGV had a GRP or geothermal resource permit to develop up to 60 megawatts of power. It currently provides up to 35. Okay? As part of its expansion activities under the GRP, which the county had already, under its home rule authority at that time under Chapter 205, had issued a GRP, provided conditions as to location, provided noise standards. And yet in 2012, which was an election year for the county mayoral position, there was a big outcry about whether or not PGV should be able to drill and conduct drilling operations under the concept that if you prevented those operations at nighttime, it would reduce noise. So what the council did, over very vehement and strenuous opposition from DLNR, nevertheless adopted this ordinance that was very simplistic in what its language was. What did that language state? It stated that basically all drilling and drilling operations during evening hours shall be prohibited. No definition of what drilling operations was. No definition of what drilling was, and yet this outright prohibition. From DLNR's standpoint and PGV's standpoint, DLNR issues what's called a geothermal well permit. Under that well permit, there's a strict set of protocols that the driller or PGV must follow. And what are those protocols? When you put a hole in the ground, you have to develop casings you go to depth to protect water quality, to prevent blowouts. You have blowout preventers, and all this time as you're getting deeper and your temperatures and pressures are rising, you're pumping mud, cooling mud into the hole in the ground. Those are all part of drilling operations. And so from PGV's perspective, it was, do we follow this county ordinances? You cannot engage in any drilling operations, or do we follow the well permit that's issued by DLNR saying you must do these things 24/7? And the irony is, following that ordinance would have compromised a number of safety concerns, both water quality, environment, and public safety. In 2012, DLNR submitted this testimony, which they can provide you a copy of, that really outlined in detail what those concerns were. The issue of home rule, or the issue of a GRP, is not exclusive to what DLNR does, nor is what DLNR does exclusive to what the county might have authority to do. And if you take a look at the, for instance, Section 3 of this SD1, it says, relating to building, grading, and flood control codes, providing that notwithstanding any other law to the contrary, the rules of the board regarding development, including drilling conditions and restrictions, shall be uniform and exclusive throughout the state. That is the primary concern, at least from PGV or ORMAN's perspective, to say, within the scope of authority that DLNR has with respect to the issuance of mining leases, issuance of well permits, or requiring adherence to the plan of operations that a geothermal operator must follow. Those kinds of restrictions and conditions need to be uniform and exclusive, because if we don't do that, or you have an agency with substantial expertise that has engineers on boards and knows the history of geothermal operations, that's something that must be reserved to the state. If we deal with other issues such as home rule, that's a different issue. Noise standards, DLNR's rules do not deal with noise standards. The GRP did, which PGV has followed. So I just wanted to explain the dichotomy that exists between the state and county jurisdiction issues that are at play here.
Okay, thank you. I understand now better what the concern is, but with the way the bill is written, it would override, where the state would override zoning as far as it goes to geothermal drilling, because all it reserves to the county is building, grading, flood control codes, but it doesn't specifically apply to the zoning. And the language is very clear that it, shall be exclusively reserved to the state. Are you, what you just described?
Yes.
would keep the zoning authority at the county level.
It does not take that away.
Okay, so you would not oppose clarifications to say that the county would still retain the authority to zone for the types of locations within the urban district where geothermal would be appropriate?
I think that would be something we would need to talk about, but I don't think ORMAT or PGV has a strong objection to that.
And then would you be okay with the noise or other things to have the county have the ability to regulate that? Because, this is pretty limited on what it specifies the county would retain jurisdiction over.
Well, on the noise issue, under the chapter that relates to noise, DOH has already provided under its rules the authority for the counties to deal with what's called excessive noise.
Okay, so you would be okay if that were also specifically retained?
I think that's already reserved.
Just for clarification's purposes, because when I'm reading this, I don't read it that way. So, and I'm not, opposed.
Yes,
So-
understood. So that's the basic background. The current operations, I'll give you an example, because I've listened and read some of the testimony here today. The current plan is in an agricultural district. Since 1991, there's been approximately 700 building permits obtained within 1 mile of this facility. Approximately half of those have involved additions to or renovations to existing structures, meaning people who live there have wanted to add on and improve their facility.
Maybe they're soundproofing.
Well, I think the whole
teasing.
idea there is, you get the point, right? That's not been the situation. So that's kind of where we're at this point. DLNR has its role. Let's not mess with what it does. From a zoning authority or land use perspective, that's what we can.
So the concern I would have would be urban district, obviously where it's exclusive authority to the county, but also agricultural district where it's shared jurisdiction between the county and the state. And again, this to me is a industrial, at minimum light industrial use. And you have certain agricultural areas where they're very small lots, very close together. The county has, I'm not familiar with the Big Island, but City and County of Honolulu has pushed the industrial agricultural uses onto the Ag 1 district and away from the Ag 2. So, would you continue to have the county to have that ability, to be able to do those zoning decisions, I think would be very important.
Okay, understood.
Yeah.
Understood.
Chair,
Any question? Yes, Senator Ruderman.
For Mr. Ye.
Yes.
Is PGV currently involved in litigation regarding the nighttime drilling?
Well, that's a really interesting question because in 2012, during the discussion by the council that predicated the vote that was taken, the discussion was clearly that the ordinance was not intended to cover PGV because of vested rights and equitable estoppel issues, given that it had already been issued its permit, invested a substantial amount of money for its current facilities and future operations. So that's one of the issues that has not been decided. The court did not outright deny or reject the arguments we were making. What it wanted was the state to be brought in as a party to participate in the action and provide its position from DLNR's perspective. So it's still pending.
So it is still pending?
Yes, it is.
One of my colleagues was asking, why is nighttime drilling? Why is that a big issue? One would think that geothermal is you drill the wells and then you run the power plant. How many wells has Puna Geothermal Venture drilled so far? Please, approximate.
I think they have the GRP allows them to drill up to 30, 28. They currently have, last question? 12, right? Yeah, 12 or 13 or something.
Was the original plan for just 3 wells, two resource and 1 reinjection? Am I correct about that?
I think the plan of operations specified a total number of wells. As far as whether it's used for production or injection, they didn't get that specific. Because
Do you
sometimes
remember what that number
no,
was?
I don't have that number. Sorry.
And one more comment, too, is I think Senate Draft 1 no longer has this retroactivity clause. So it's not an issue with respect to litigation at all.
Any further questions? Yes, Senator Revere.
Thank you. It's good having both of you guys there because I think we all have the same questions or to you folks. So what are obviously there's a concern on Hawaii Island for noise or inadvertent leaks of sulfur dioxide and such. How is DLNR doing everything it can? What would DLNR do differently should this law be passed? Would DLNR now step forward and step in if there's inconveniences to residents or other people living in the area? How would we go forward?
When you mean inconvenience, are you talking about something related to well drilling
The
or
noise
something related
complaints
to?
as an example.
Well, authority doesn't allow us. That's why DOH is very important in part of this conversation because when it comes to emissions and noise, they have clear authority to take action. I think our testimony, as you read it, was limited to the drilling when it comes to exploration and development. So, we need to work closely with Department of Health, but we don't have the authority to go enforcing, things like H2S emissions and noise and so forth, which the DOH currently has.
So going forward, as additional wells are designed and considered, how might DLNR process these differently? Or will the same process be followed? And what's more, it seemed to me when we wiped out that chapter a few years ago, we took out a lot of public input. And please tell me where the public input will come forward.
Well, I think when Act 97 was enacted, it took out one process. It took out the authority of the counties to issue a geothermal resource permit, which is a land use entitlement, particularly. That doesn't exclude a developer from Chapter 343, which is the environmental review process. It doesn't exclude the public from testifying when a developer wants to come to the Board of Land and Natural Resources for a mining lease or any other permit that comes before the board. I presume that absent of a geothermal resource permit, the county still would have some type of jurisdiction to issue land use, whether it's through a special use permit or a conditional use permit. I'm not sure that's something you got to count as far as the public process when it comes to land use. The board reserves the activity when it comes to conservation. So if a developer chose to develop in the conservation district, there will be another opportunity when...
Well, I'm sorry, but let's suppose this company, Puna Geothermal, PGV, they want to go forward with up to their 30. I understood there's 30 permits allowed or 30 wells.
Yeah.
Is there any more public input on those, or are they clear to go to add as many as they wish up to 30 at this point?
Right now, the EIS that was done, my understanding is that was done back then. The mining lease they have currently allows them up to 60 megawatts. So as far as the public process, those are already vetted unless they would be deviating from their original plan of operations.
And maybe the county of Hawaii really doesn't want geothermal in a particular area. You say, wow, that's a great resource. Too bad, right? DLNR is now going to make the decision.
Well, DLNR our role is purely regulatory. So someone have to come to the board.
But who makes those discretionary decisions? What's the process going forward?
As far as someone coming to the board, they would have to get a mining lease. So the Board of Land and Natural Resources would have to approve it when they come for a mining lease because it's a public trust resource. That'll be one discretionary action by the board. If they were to do it in any county, whether it's in agro or urban, I believe there's still a process, whether the GRP that everybody's talking about is restored, or if they have authority to issue a use permit or some type of special use permit. That's something the county may have jurisdiction absent of a GRP.
Okay, and then, sir, Mr. Yee, what are you restricted from doing now? What is the company restricted from doing now that would be allowed if this bill were to go forward?
Okay, that's a pretty broad question, but Just from a regulatory oversight
Laws can open up in magical ways.
Well, from a regulatory perspective, understand that from the standpoint of either water or air issues, you have the DOH controlling air emissions. There are monitors for that. EPA also regulates what PGV does. Within the context, of their current GRP, which they already went through a public hearing process on, and which they are still complying with, they still have to comply with the terms and conditions of that GRP. That's what we're operating under. And those include BACT standards for noise emissions. If they were to go somewhere else, as Mr. Chang indicated, yes, they would have to go get a mining lease. There would be a hearing process before the board. The county has not yet specifically regulated the use permit issue. All it has on the books right now, at the moment, is this prohibition against all drilling operations during evening hours.
And that's important to the company.
That's
the company
very
needs to drill at night.
Very important. It's not just drilling; it's everything that goes with it.
Yeah.
And I'll give you an example. I mean, during the evening hours or any time, there's noise that goes on even though the drill bit is not moving, because you're having to do all these other things to deal with the safety protocols. As a result of the last set of BACT measures that occurred during the last well that was drilled, basically the noise emissions that came from that facility during the drilling operations was very close to residential daytime standards. So the fact is that there is a really good opportunity to continue to comply with what's there and what the community desires.
Thank you, Chair.
Okay, Senator Nishihara?
Irrespective of either bill, the regulations that govern public health, whether it's noise standards, air emissions, that doesn't change regardless what this bill is. So the concerns that raised right now about the noise standards, whether you do it during the day or at night or whatever, they have to comply to whatever the standards for the Department of Health, as it is already, regardless of what the approval process is. They still have these. They don't go away. So what are we basically trying to slice up in this one that you see is so different that if we pass one or the other, really will make a difference in terms of its operation, the public health concern, or the public's protection?
Well, that's a really good point, because DLNR's protocols for drilling are intended to protect public health, intended to protect water quality and the environment. And yet, when we had this county ordinance that basically said you can't do those things, that's the problem that has been created that I think this bill attempts to address.
Thank you.
Okay. Sure. Any further questions?
Sure.
Okay. Yes. Senator Gabbard.
What are PGV's plans now that they've pulled out of the 25 megawatt RFP?
Okay. Mike Kilikini, PGV. Am I going to promote you? Can you give your status?
Yes, no, thank you, Chairs Inoue and Nishihara. So, Senator Gabbard, our intentions right now is just to focus on operating the current plant in a safe, reliable manner. So the RFPs essentially stopped for now, and we're going to focus on PGV.
And you're at 38? Is that right?
Our contract with Helco is at 38, and we've got some work to do and some maintenance, but we're slightly below right now.
Thank you, Chair.
Okay, thank you.
I have a chair for
Yes, Senator Ruderman. For Mike?
For Mr. Kilikini, thank you, I'm sorry. Is this bill something you need for your current operations or anything you have planned right now?
Well, this bill, again, will just make it clear that DLNR is the primary regulatory agency overseeing the drilling operations.
But I believe it's your position that you have all the permits you need to continue to operate as you've described it. What change? Do you need a change in the law to operate, or are you legal the way you are now?
our position has always been that we're legal, but us being in the courts doesn't speak to that.
Excuse me?
We're going through that litigation that you referred to, right?
About the nighttime drilling?
Right.
Or about the harm from the Isabel hurricane blowout?
It was about the nighttime drilling. It's Third Circuit Court.
It appears to me that this bill would not affect that. I think that's what I just heard your attorney say, that this bill would not affect that. Does PGV need this bill, or is this for some future theoretical?
From me, my perspective, it is the geothermal industry that needs this bill to make this more concise and clear on who oversees the geothermal resource.
But we're talking about some future geothermal development, not PGV as it stands. Am I correct?
I'm speaking, it'll affect us too. I mean, right now there's that confusion, right? So clearing this up would be very helpful for geothermal, not just PGV, but geothermal in general industry.
So you're saying this bill will help settle the litigation that's ongoing that you're involved in?
I'm saying it'll just clear up who is the primary regulatory agency that's overseeing geothermal resource.
Pardon me, I'm not trying to belabor the point, but you've been clear all along that you're operating under the law. Your permit is perfectly valid, right? This bill doesn't change your permit, am I correct? Or do you need this bill to make your permit legal somehow?
Nope. Our position is that we have all the permits we need.
Okay, thank you.
Yeah.
Thank you, Chair.
Okay, thank you. Yes, Tom, please. Clarification?
In response to Senator Ruderman's question, if they need to go up to their 60 megawatts and they get another contract, and they need to drill another well, then it's going to again be, do we follow this ordinance that's on the books that makes no sense from a safety perspective? Or do we follow the well permit requirements that DLNR establishes for safety? So that question is still there. It doesn't go away.
Don't you go up to 60 megawatts on your current permit?
Under the GRP, but not under each and every well permit that gets issued or each and every well that gets drilled from here on out.
I see. And the way you did that county ordinance, what was the word you used to describe it? I'm sorry. It was what kind of, the county ordinance, you don't believe that it's a good bill, obviously, right?
Well, obviously it has no definitions. It doesn't even address noise.
Why do you think the county passed such a bill?
Well, because, there are a lot of reasons that I can provide. First,
have you ever been near the? Have you ever tried to sleep near the within a mile?
I visited the site during operations. I went to the perimeter. We listened to the noise. The Kochis were pretty loud too.
So why would the county council pass such an, I forget what you described it, absurd, unreasonable law? Why would the county council do this? I mean, doesn't that express the democratic will of an elected body? I hate to see it disparaged so much when it was passed to protect my neighbors.
Well, politics is a strange animal during election years. And when you stacked up the provisions of that bill against what DLNR had provided in the way of testimony and the rational science and the engineering that was involved, it did not make sense.
Don't bills often
and it
pass
still
in
didn't
the face of opposing testimony?
Well, in the face of scientific testimony sometimes.
Oh, I see. The science is 100% on one side then, right?
Well, take a look at their testimony as to why.
Were they protecting the citizens that live near the plant?
Yes, they were.
Thank you. Thank you.
And I'm talking about DLNR. When it submitted its opposition.
That you disparaged so extremely, I believe it was passed to protect my neighbors. Now, you don't think that's a worthy reason to pass a bill, but we do.
Ironically, it did just the opposite.
Thank you.
Okay, thank you. Any further questions? Is there anyone else here who wishes to speak to SB? I can't remember my numbers already. 2535 SD1. Okay. Hearing none, then this concludes the triple committees on transportation and energy, public safety and military and international, intergovernmental affairs, and the committee on water, land, and agriculture. Okay. Water, land, and agriculture and the Committee on Public Safety, Military, and Intergovernmental Affairs. I think we got it. We'll be making decisions tomorrow. For the Committee on Transportation, it will be meeting in room 225 tomorrow, February 17th at 3:05 p.m. And the Committee on PSM?
Committee on PSM will join you at your slot.
Okay, at 3:05 in room 225 on February 17th on Wednesday. Waterland?
Waterland Ag will do ours at 2:51 tomorrow and 2:24.
Okay, thank you, members, and thank you very much for bearing with us, for you folks as well. We have members of the transportation. We've got two more items for public hearing.